Charitable Trust Institution of Actions. Section 101 of the Trust Ordinance provides that if there is a breach of charitable trust, or whenever the direction of the court is necessary for the administration of charitable trust, then the party can apply. Who is the party? Who has the power to apply to the court? AG in ex officio post, he can file an action, or two or more persons interested in that trust, having obtained the consent of the Attorney General, may institute an action. This is in relation to the charitable trust. But 102, section 102 of the Trust Ordinance provides that is something you can file an action in relation to the religious trust. That means if anything falls under 102, then you can't file action under 101. Then if you go further detail in 102 deals with the cases by interested persons or the person interested in religious trust. Any 5 persons in the section 101, we have seen only 2 persons or 2 or more persons with the consent of the Attorney General in writing. But in 102, that's a religious trust. Any 5 persons interested in any religious trust other than the Christian religious trust. Because Christian religious trust, if there is an action in relation to the breach of trust, or if anybody wants some directions under Christian religious trust, they must go under 101, not under 102, because 102 very clearly provides that the Christian trust will not come under 102. Then further, who is interested persons? That's again we must define this one. Interested person are no need to have monetary or immediate interest, or no need to take any part in the management of the trust. Then this is something they don't, or they are not directly involved in that one by giving money or by taking part in the administration. Then who is interested person? Interested person may be as a donor who has contributed something to the trust or the administration of trust, or any person who for a period not less than 12 months has been in the habit of attending at the performance of worship. The worship, if you attend continuously in a place like a temple or somewhere, then you are entitled to file an action. Then the third, the person who makes contribution as donor or make a contribution, or person who takes part in any distribution of alms. And finally, any person who enjoys the benefit of such trust. Then when you see interested person is not interested, not any taking interest directly in the trust. No, not like that. Or he has contributed anything, or he must be a member of the board, or not like that. Any person who has some sort of interest. If a person who is getting some sort of benefit in the trust can file an action. But the thing is, there are some limitations or restriction to file an action. Under 102, the interested person, even though 5 persons, there's a mention that 5 or more than 5 persons, interested person can file an action. But they can't file action directly in the court. Then they must follow some procedure established under this section. First of all, the interested person must submit a petition to the divisional secretary for appointing a commissioner or commissioners to inquire the matters specified in the plaint. That means as a interested parties or interested person, they must get together and prepare the plaint. They must put all the matters in the plaint. That's generally in the district court, the lawyers file the plaint. But here they must draft the plaint, and also they must prepare the petition and submit to the divisional secretary. Then the divisional secretary must satisfy the 5 of them are person interested. Then what they should do is, sometimes the divisional secretary asks the parties to give some affidavit to ensure that they are persons interested. Then thereafter, if he satisfied that they are interested parties or interested person in terms of section 102, then the commissioners must be appointed. When the divisional secretary appoints the commission or commissioners, he may appoint himself as a commissioner, or sometimes he can appoint some other commissioners. In addition to that, they must submit these plaint and petitions. In addition to that, petitioners must deposit the amount or sum of money to cover the reasonable expenses if required by divisional secretary. Then further, at the end of the inquiry, the report will be rendered to the divisional secretary. The commissioners they have the power to summon the witnesses, and they can see all the documents, whatever they want, they can ask to submit. That should be done. Otherwise, if they fail to do that, that is an offense. The report, what is the report? Then report may specify that sometimes this is the matter is something difficult to decide by commissioner, that should be decided by court. Then they calls for a core consideration of court. Second one, sometimes that cannot be. There is no possibility to come to the amicable settlement. Then you must say that no, the report you must mention, the commissioner must mention that we can't settle this issue. Or otherwise they settle, the amicable settlement is there, but they want the assistant of the court to implement that amicable settlement. Then they can put everything in they write everything in the report and submit to the divisional secretary. But the procedure, these procedures established in section 102, not in 101. Then the procedure specified in 102 shall not apply to the Christian trust. That is there's a black and white provision in the 102. Therefore, Christian trust should go under 101. Section 101 and 102 do not bind the authors or trustee of the charitable trust from applying to the court for a direction or relief. Now this is what we have studied now. As a person interested, if they want to file an action, they must follow these procedures. Interested person only. But what we have seen on 101. 101 also again, they must get Attorney General consent in writing and file an action. But as a trustee, as an author of the trust, there is no bar at all to file an action directly without following these procedures. The author of the trust or the trustee do not follow the procedure established in 101 or 102 to file an action in the court. Then they have the full power to file an action. Only in relation to the interested persons, they must follow the procedure. Once the commissioners completed their inquiries, finally they have given the report to DS. Then the DS shall certify that inquiry has been held, and the commissioners has reported, as I mentioned, that this is subject matter which is requires the consideration of the court, or sometimes they can say that this is not possible to possible to come to the or bring to the settlement or amicable settlement, or sometimes they can say that there's an amicable settlement, but we want the assistance of the court to implement it. Then whatever they have mentioned, then everything they put together and give the certificate that these are the matters held, the inquiry held, and report is this. Upon the submission of certificate of DS, action may be instituted. Then as an interested persons, they can file an action directly. If it is a charity or charitable trust or Christian trust, they must go to the Attorney General and get the consent. If it is other than religious trust, other than the Christian trust, then they must go to the procedure to go and submit a petition and plain to the divisional secretary and follow the procedure. Everything is over, then only finally they got the certificate from the DS and file an action in the court of law. The court may, on the application made by parties, refer the matter to the arbitrators. That is the power of the court. Or otherwise, court itself may appoint another committee for a report, sometimes for report what is there, to know the report. Or otherwise, appoint a committee to assist the court. Or sometimes appoint a committee for settlement or adjustment of any matters. In settling these matters, or in settling any scheme of management, the court shall have regard to the, first of all, the instrument of trust, that is the trust deed. Then they must see the trust deed first. The court, that's a shall, not may. The court shall have regard to the deed of trust. Second, sometimes there may be religious law, then the court must look into that also. The third one, the customs of the community. There's a trust, then what is the customs in the community? Then finally, the local customs or the practice with reference to this trust. There's a trust for more than 100 years. There's a traditions and practices and customs relating to that one. Then that is also tradition, that is also custom or practices, that also must be taken into consideration. Finally, if a trust regulated by Buddhist temporalities ordinance or Muslim Mosques and Charitable Trust Act, then it should be governed by that act, not by this one. The first point is, if it is regulated by, if there's a trust which is regulated by Buddhist temporalities ordinance, then these provisions are not applicable to them. Then they must go to the specific act or ordinance, temporality ordinance. Then if it is a Muslim trust, Muslims, mosques and Charitable Trust Act is there. If there is no inconsistency between that act and this trust ordinance, then they can follow here. But if there is an inconsistency, then they must go to the Muslim Mosques and Charitable Trust Act. This is the dispute or the institution of actions under charitable trust. Thank you for watching this video.